Hello, hello, hello. Good morning, everyone. It is Thursday, November 19th, and I just want to first express a giant thank you to all people who are attending. We are extremely excited about today, but before I get to that, some preliminary announcements as we always make them on this session. First, our forum is private, but our videos are public. So as always, please be advised that any and all questions that you have or any comments that you make on this video session are being recorded and will be put on public channels. Second, I just want to thank everyone. We're now at 4,200 members strong in our group. That is an amazing number, especially because really there's only, I think, what is it, like 30,000 practicing agents in Ontario that are doing significant deals. That is a credit to all of you. I find that the caliber of our discussion is getting better. I find that the caliber of our lawyers. Sorry, guys, can I think there's, if I can ask you all to mute, please. Not sure. Stuart, this is you. Let me just, I'm just going to mute everyone if you don't mind. Where's Stuart? Stuart, you're, okay, hold on a second. All right, guys, if you can all please mute yourself, I'd appreciate it. That's a testament really to the caliber of the lawyers, the caliber of the realtors, and our desire to ensure that we deliver proper legal answers to proper legal questions. I just want to thank everyone for that. Let's turn our attention to today's activity. So we are privileged today to have Alan with us. Alan Dreyer is with Sherman Brown, and while I did not know Alan beforehand, I certainly knew his firm. I've been dealing with Corey Sherman of his firm for many, many years, who is actually my go-to person for commercial leases, an excellent mind, a true gentleman, someone who, if you do have commercial lease deals, is someone to look up. Of course, the fact that I didn't know Alan prior to this event doesn't mean that he didn't come highly recommended. In fact, our own Barry Sherman has gone ahead and recommended Alan.
Barry Lebo.
I'm sorry, Barry. I'm sorry about that. Wrong Barry. I'm sorry. Our own Barry Leibowitz has gone ahead and recommended Alan. And as we are all aware, based on Barry's contribution both to this group and to our industry, a recommendation from Barry is gold. That, to my mind, is actually the gold standard. And certainly gives me every confidence that what we're going to hear today is going to be exceptional and will answer the questions that you've had boiling up. Before I turn to substance, one last point, and that is why we are doing this. We are doing this today because most of the lawyers who the people on this forum engage with on a regular basis are lawyers who do conveyance. That is to say, they have a single job, which is to make sure that fundamentally a transaction gets completed. And those are the lawyers that you know, and you call them real estate lawyers. And truthfully, they are. They deal with real estate. But where their competence ends, generally, not for everyone, but most, is at the point when a deal falls apart or concludes. And if it falls apart, the competence of a real estate conveyance lawyer is to properly document the file and then turn it over to the next step, the litigation lawyer. And it's there that most people on this forum have a gaping hole in their knowledge because they are interacting regularly with the conveyance lawyers who understand how to bring it to a litigation lawyer and nothing thereafter. Of course, your clients are not satisfied with that lack of knowledge. They want to know what's going to happen next. And the point of today is to describe that next step. What happens once this is brought forward to litigation? So without further ado, Alan, I trust you are prepared to go, as am I, and I'm going to start with a couple of questions, and then we're going to open it up to the group. This is going to be an informal session of just back and forth today.
Great, thank you.
Do you want to say anything before we begin, Alan?
No, let's get rolling.
Let's get cracking. All right. So the first question I have is, if something goes wrong, and we are saying, okay, you need to go to a litigation lawyer, the very first question that is asked is not even, okay, what's going to happen or anything else, but rather, how much will a basic consult cost? And I wonder if, firstly, you can just speak to, all right, just to even find out what my next steps are, to have this dialogue with my litigation lawyer, how much does that cost?
I mean, I guess I can only speak personally, usually a quick 5-minute phone call doesn't cost anything. for me to find out, is there something I can act on? Is there a file I can take on, or is there not? If there's not, 2-minute call, 5-minute call, we're done, no charge. If there's a file there, then it depends what we're dealing with. I mean, I ask for retainers to get going, and it depends, are we seeking a certificate of pending litigation or filing a caution, or is this something that can be resolved in a few phone calls? Are we writing a letter? You know, usually it's going to take, you know, $1,500 to $2,000 in a more complicated matter to get a handle on what's happening, review, search, understand, and write the first letter, something like that in general terms.
Understood. So Alan, let's break it down, because there's obviously various avenues that are regularly taken on by a litigation lawyer. And the very first one is one where someone simply wants to have the deposit paid to them and they're prepared to walk away. So they don't want to go through the whole rigmarole of a certificate of pending litigation, which we'll discuss later on, or any of that jazz. What they want is, they say, I want the liquidated damages according to me because my buyer has walked. What is the if someone were to come to you with the simple facts that I'm about to lay out? There's an agreement of purchase and sale. It was firm and unconditional. The buyer, without dispute, has gone ahead and breached the contract, and proper tender was effected. What would the cost of an action to recover the deposit alone generally cost on those facts? Understanding that litigation can take all sorts of twists and turns, but assuming that it is as simple as I am laying out, because people are constantly trying to figure out, do I sign a mutual release and get back a portion, or is it worthwhile us going to court on these facts, which are largely the same facts over and over again? What would the cost of such an application be?
Well, as usual, there's no clear answer on that. First of all, it depends on the amount of the deposit. So that is a question of what's the jurisdiction of the different levels of court. If the deposit is $35,000 or less, the action can be brought in small claims court, and it's a lot less expensive. If it's between $35,000 and $200,000, it's what's called the simplified procedure action. It can be brought in superior court, but there's restrictions on the procedures that can be carried out, on discoveries and on motions, and therefore it's theoretically a less costly exercise. Above that, above $200,000, you're dealing with a full-blown civil action. So, you know, I mean, most often, you know, these matters can only be settled. If they can be settled quickly, usually the legal cost is going to be low. I mean, sometimes it's just a matter of a series of phone calls and work something out, and there's no need for a lawsuit. But right, the minute you're into a lawsuit, you're into thousands of dollars in legal fees. And, you know, if you're into a lawsuit that's not going to be settled quickly, you're into tens of thousands of legal fees.
And in terms of if I may just try once again, and I appreciate where you're coming from, Alan, it's incredibly hard to talk about this in a general sense. But with your permission, I'm going to actually try to specify my questions a little, because I know the questions that agents on this channel have. If it is a small claims court matter on the basis of the facts that I've described, and it goes to trial, it is not settled. There's the pre-trial, and then it goes and you have your half a day in court. What would the cost of such an activity be in small claims? And I'm bringing up small claims because there's less motions, there's less variability. It's more of a prescribed, understood scenario. I'm hopeful that, and it's really critical that you understand that this is functionally information that agents need in order to determine how to counsel their clients as to whether or not to sign a mutual release. Absent that, they can't really say, hey, you're able to get X, but I don't know how much it's going to cost you to get Y.
So, I mean, the ones that we have going in my office that are in small claims court are no less complicated in terms of the level of dispute and the facts. There always are disputes, even the ones that I think it's obvious who's in the right and who's in the wrong. It doesn't matter. I have actions where, you know, purchaser and seller are taking strong positions against each other. Sometimes the agents are named because the brokerage is holding the deposit and they're countering for their share of the commission. And you have 3-4 parties, and I wouldn't handle it. I would have my junior lawyer handle it, but it's still going to cost thousands of dollars because you're going to have to go deliver different pleadings, statement of defense, defenses to defendants' claims. You're going to have a settlement conference. Some of them inevitably involve self-represented parties. They involve motions. And then you have a lengthy trial delay in the small claims court. So often on your first time you're going to go to the small claims court for your trial date, you won't even be reached. You could be sitting around for hours. You could be on the bottom of the list. I have some of these cases that go back for motions repeatedly. So using a junior lawyer, if it goes smoothly to get to the end of the process, I would say is going to cost in the $4,000 to $5,000 range, potentially in small claims court. But right now it's unknown. I mean, they're very backed up. They're holding virtual settlement conferences. In some cases, they may have to go to virtual trials. In a way that can cut costs because, only having to show up on Zoom when it's your turn is in a way less time consuming than spending a morning sitting in a courtroom, seeing if your case will be called or not. But I think no matter how simple the scenario you give me, it's going to end up being complicated because everyone will put their maximum position possible forward through a lawyer, or self-represented parties will take unreasonable positions that they can't back up, but they will fight very hard to back them up in small claims court. And the judge will give them every benefit of the doubt because they don't have a lawyer, and listen to them at length and let them get away with procedures that a lawyer wouldn't be able to get away with, give them more leeway, and it just becomes time consuming.
Alan, I realize that I'm asking you very unfair questions. So please do not in any way think that we do not appreciate the position we're putting you in by trying to nail this down. And I appreciate your answer. I get what you're saying. What you're effectively saying is, look, if you're using someone, we may have a $5,000 cost, but they can vary so wildly as to cost and as to procedure and as to events that you really need to be sure that people understand how the court process works, which is that variability when giving any sort of estimation at all.
Yes, let me add one thing. Almost every one of these cases should be settled. It is not cost effective to go through our courts. It will end up costing too much money. Once it's there, it's expensive to get out of it. People who have, let's say in August of 2017, where there was all these deals from the height of the market in February, March of 2017, then the market fell dramatically and a lot of people were willing to walk and not willing to close. I just spent a lot of time on my phone where matters were referred to me, just trying to cut deals. There's the market's gone down by 200. Let's drop the price by 100. Let's cut a deal. Let's close it, because the consequences are going to be worse. The damages are going to be higher. They're going to be hard to recover. Everyone's going to be punished by waiting through the legal process. And I have lots of cases that were too difficult to settle and too much at stake to be settled. And now they're just dragging on forever. People can't collect. People can't pay their lawyers. It goes on and on. The courts are slow to deal with anything, even when you give them the opportunity to. So early, cost-effective settlement is by far the best route to go, even when you're giving up some of your legal rights to get there. It's always more practical and cost-effective. The earlier, the better. The less, don't rely on the courts to get you to a practical, cost-effective result. It won't happen. It never does.
Excellent advice, and that's born of my own personal experience as well. So that's excellent advice, Han. Alan, I'm going to just pick up on, and I do apologize. I'm monopolizing your time intentionally for the first 25 minutes or so, and then I'm planning on opening it up. But you did mention collection. Now, again, let's put ourselves, we have a couple of lawyers on board here as well this morning, but we have realtors primarily in our group. And the situation that most realtors are in when a deal goes south and they're saying, hey, perhaps we should consult with the litigation lawyer, is they're going through largely what it is every person who has a litigation claim has to go through. Is there an actionable wrong? And usually they know that part. How dare this person do it? They breached the agreement. That's not fair, yada, yada, yada. And then, is there damages? And part of the damages, as you mentioned, is collection. And ultimately, if you're dealing with a buyer that has no assets and no resources, going through the whole process to be proven right, to be able to prove your damages with your expert reports and everything else is of no consequence if fundamentally you're trying to get blood from a stone, as I'm sure you're aware. My question for you is therefore this: how does a layperson, how does a real estate agent or someone else, are there mechanisms by which they are able to figure out if it is even worthwhile pursuing buyers who may in fact have no real estate assets? Are there resources available that can assist with that? How do you as a lawyer assess whether or not, even upon success, there will be collectibility?
Well, usually it's fairly obvious right from the start. Often, at least on commercial transactions, you see a lot of purchasers are an individual in trust for a company to be incorporated, or a newly incorporated single purpose numbered company that's incorporated to purchase an asset. But if the deal doesn't go ahead, it has nothing. Or if it's in trust for a company to be incorporated, even if you were advised before closing that it was going to be a certain corporation that you've heard of or that you know has assets that's been incorporated recently or whatever, it can be switched. And I've seen it switched, just before somebody's going to default in closing a purchase, they switch who the buyer is going to be. They have sometimes clauses that give them the ability to do that. Usually, unless you know of assets, you can assume there are no assets. It's possible to go online on Terranet or Terranet Express for me, and to search a name. I can do a search on the Toronto Land Registry Office by name, or York Region or Peel or wherever I think somebody might have an asset, and I can search for a real estate asset in their name. Usually I find nothing. More often than not, a lot of buyers don't have assets. Yes, there are individuals buying a residence who own their existing residence, but often it's hard to find the exact name match or be sure that it's the same person. We're a diverse society. Many people have names in different languages, use different names in different languages, and it's often hard to be sure about somebody's first and last name in legal documents. It can be often different than the name they use or the name they put in on an offer. So, I find that's a large problem, and people know it, and they do it on purpose when they buy a property, and they therefore reserve for themselves the right to walk away from it with no consequences, save and except for forfeiture of the deposit.
Fair enough. Alan, I'm going to ask two last questions, and then I'm going to open it up to people here, because I have a sense that there's going to be quite a few questions. First, I'm going to ask a question just for the lawyers. The realtors can blank out for 1 minute and take a coffee or a break for 1 second. I'm wondering if you do vendor purchaser applications.
I have done them, but not very often over the years.
I've never actually brought a vendor purchaser application. For those of you who are realtors, as you're aware, there's a requisition, and the requisition date, which is the title search date in your agreement of purchase and sale, gives the buying lawyer time to say, hey, I want the following things rectified. If the seller comes back and says, no, go shove it, actually they say, please satisfy yourself, but what they mean is go shove it, then the only person who can adjudicate whether or not the seller has an obligation to rectify it is the court. And this is brought through Section 3.1 of the Vendor Purchasers Act through what's called a vendor purchaser application. Alan, do you mind if I just quickly ask, on the time that you've brought one, what is the timeline associated with that? Is there a sort of triage action? Because usually this is done all with 2 weeks before sale. And I've often been confused as to how it is we can make that timeline work if there is not a proper response to requisitions.
I'm not sure that you can bring it in a timely fashion, given the current state of the court system. I remember bringing one in Newmarket in the 1990s, one in Brampton that I can recall. And back then, those courthouses were less crowded, and you could get in on this type of application quickly and have it heard before closing. Your chance of being heard now is, it's not high. The court might say it's not urgent enough. Go tender on each other, go stake out your positions and come back later. Go find a way to close, and hold the money back in escrow and then fight over it.
Fair enough. All right. Interesting. Last question for me, and then we'll turn this open. I want to keep on with the questions that are relevant to the realtors here. So if a seller chooses to default, and this actually happens more regularly than you may think, sellers have a change of mind, they say they just don't want to sell. I've had that happen actually twice this year. Can you explain exactly what the process is for bringing about a caution on land, then the certificate of pending litigation, what that means and how that takes place? So I'd like you to kind of explain to people, without even dealing with costs or timelines, just what the procedure is and what the recourse is for a buyer when a seller defaults.
Well, first of all, I think you have to decide, are you pursuing specific performance? In other words, are you going to attempt to go to court to compel the seller to sell the property? In order to have that right, you're going to have to meet a test of uniqueness and show that your loss is not just one of money, but it's your loss is, you're going to suffer irreparable harm, and this irreparable harm will be because the property is unique to you. It has unique qualities, and of course, in as many decisions that there are from the courts on this point, there's as many disagreements on what is the level and scope of uniqueness. Typically, an investment property, one that you purchase just to earn a return on money, on your investment, is not considered unique or sufficient. If you own one lot and you have an agreement to purchase the lot next to it, that's going to be a very unique property because there's only one lot that's next to yours that you can bring into a land assembly, let's say. But then, so assuming you're satisfied that you have proper legal grounds for specific performance and not just damages, there's two ways to tie up a property. One is filing a caution, which can be done by a real estate lawyer without a litigation lawyer. It can be registered on title under the Land Titles Act. I believe it lasts for 60 days. There's some types of caution that last 60 days. I think there's a type of caution where you're registering an agreement of purchase and sale that lasts longer. But you have to, in order to register it, you have to be claiming an interest in land. Then you have to go to the courts and start a lawsuit for specific performance. And you're going to have to bring a motion for a certificate of pending litigation to replace the caution registration typically. And you're going to have to prove to a judge or a master of the court that you meet the tests for uniqueness and specific performance on a preliminary review of the case that are strong enough to tie up somebody's land. And, sometimes they're brought without notice to the seller. Sometimes they're brought with notice to the seller, but one way or another, the seller has the right to challenge that tying up of their property in court and can oppose you on equitable grounds or remedial grounds or challenge your version of who was in the wrong under the agreement of purchase and sale. And that can be quite a costly process. So, you know, the motion going back and forth on specific performance and a certificate of pending litigation can easily, you know, get to $50,000. And if you lose, you pay the other side's costs. So if you don't have a strong case on uniqueness and the property's maybe not worth it, or the market is shifting against you, then it might not be worth having all that, taking on all that risk. You know, also specific performance, if you're a buyer, means tying up your deposit. You might rather have your deposit back and go buy another home for your family rather than fight 3 years in court with your deposit tied up.
If I may just make an addendum question, even though I said that was my last, would it be deemed, in your mind, would specific performance be met by virtue of school district? That is to say, I need this property because it puts my child into a school district, which I need for next year, which is really the uniqueness of a condo, because condos are really just glorified washrooms in the sky. But at the end of the day, the school district is a unique requirement, and I've seen that being made several times. Would that satisfy, or given the fact that there's so many unique washrooms in the sky, is that perhaps likely to fail? I'm just trying to judge how a judge would see this.
I think it's a potentially strong argument. I mean, I think the case log, I haven't looked at it lately on that issue. I think the cases tend to go all over the place, and the court, in each case, they'll look at many factors about the buyer and the property, assess them all. But I guess my personal opinion is that school district does motivate a lot of purchasers. Personally, I sold my previous house to somebody whose main interest in the property was what school district it was in. They wanted to get their child into French immersion. They wanted to start in SK, and they needed to buy in my neighborhood, and that was good for me. And that meant a lot to them. So I think the courts will probably move more and more toward accepting that, because it's becoming such a key factor in the purchasing of homes nowadays, whereas it might not have been 30 years ago or something like that. So, but I don't know the current state of the case law. I'd have to look a little more deeply. But my gut tells me that that should be an important factor.
Excellent. Okay, I'm going to, I do have a question later on about good faith and how we interpret contracts and specifically conditions in the contract, but I'm going to leave that to the end unless someone else chooses to ask that exact same question now, because I'd like to give people an opportunity to actually speak. So without further ado, would someone like to actually ask Alan a question here? Please feel free to do it verbally or in writing, and I'll read it. Anyone is free to jump in now. If not, then I'll ask my next question. Nope, we've been answering all questions. All right, Alan, I'm gonna jump in then with my good faith question, because I think it's actually applicable to most. Oh, thank you, Nick. Yeah, I think it's great too. So, Alan, very quickly, we have conditional offers that are brought. And of course, you're very familiar with that. You're aware of what the conditions are. As you're aware, in 2016, I think it was 2016, Bassin and Harnu came down, good faith obligations and all that jazz.
2014.
2000, thank you, Sandra.
November 14, 2014. You knew I'd know that one.
I did indeed. I hang my head in shame. All right.
No.
So yeah, in 2014, we have Bassin and Harnu that comes down and dictates good faith. A lot of people ask, as they feel that people are pulling out of financing conditions, and as they feel that they're pulling out of home inspection conditions for reasons that have very little to do with financing and home inspection, as to whether or not a good faith claim can be asserted because they are not now conducting themselves in that manner. Can you speak a bit to that? And can you also speak to how Bassin and Harnu has been interpreted by the courts in the context of the normal OREA agreement since it came down in 2004, in November of 2014? Thank you, Sandra.
Yes, I mean, I seem to be dealing with good faith constantly on commercial lease disputes. And it doesn't come my way that often on agreements of purchase and sale. I think it's important to know that if there's no accepted agreement of purchase and sale, there's no duty of good faith. There might be other duties involved, but until there's a contract in place between two parties, there's no duty of good faith that arises. It's a duty of good faith, honesty, and fair dealing. So it's really a three-part duty. And it arises when there's a contract between parties and the performance of the contract. So I think, I'm not, again, right up to speed on the case law, but I think it's important how those clauses are worded, sole and absolute, unfettered discretion, all that kind of wording that lets it know that a party has a scope of behavior. But I do think there's a bottom line that if somebody challenges the exercise of a condition, that people are expecting now that there will be some evidence. If it's a financing condition, people will want to see that a buyer applied for financing and either couldn't get any commitment or got a commitment that was unaffordable or unusable. If somebody wants to exercise a condition based on inspection of the property, you'd want to see some evidence that they had an inspection made or soil testing done or HVAC systems reviewed or whatever it was, and they came to some reasonable conclusion based on some evidence to support what they were doing, and they weren't just using that as a way of speculating or playing on the market or seeing which way the wind was blowing in order to tie down properties and then get out of them just because they felt like it. I do think the courts are going to move in that direction because it's not just good faith. It's a duty of honesty and it's a duty of fair dealing. And if a lot of those are examples of unfair dealing, and I think the courts are clearly moving toward holding people's behavior to a higher standard.
Right. So the way that I think a lot of agents are trained is that obligation exists for almost all conditions except for financing, because financing can be a subjective, I just plain don't feel that this is something I should be, this is plain, I'm just not comfortable with the amount that is being spent. I didn't realize how much the principal and interest is when I do out my amortization calculator. They see financing as much more of a free, get out of jail free card. Whereas I think that the eloquent way that you've described the requirement to act in certain manners, fair dealing as you call it, for the purposes of inspection, for the purposes of soil inspections, environmental, whatever it may be, all of that is absolutely the case. Is that understanding correct? Or is it, maybe you just don't know the answer to that? Maybe it's not something you've encountered.
I don't know the answer to that because that almost never comes my way. I think it's real estate lawyers and agents mainly dealing with that a lot more often. Sometimes it comes my way the odd time somebody challenges it. And I think it's probably important for the people watching this program to create, if you're applying for financing or your client, or you're carrying out an inspection, make sure you have some record of what you've done. Make sure you can prove that you've taken steps. I don't think financing conditions means that you have to go ahead, but I think you have to have attempted to get financing, and either you can prove that you applied and didn't qualify, or you can prove that you received an offer of financing or commitment that was unacceptable to you. And I think, I don't think a court's going to get too deep into looking as whether was it a good interest rate or a poor interest rate? Was it
Can I just ask, it's Ty here. So when you have an argument of good faith, is it the person that is claiming that you didn't proceed with good faith? Whose obligation is it to provide the evidence? Is it my obligation to provide that they did not have good faith, or does the claimant have to basically prove that they had good faith. I guess what I'm asking is who's got the duty of evidence here?
I think if a person, a buyer is using a condition to get out of an agreement, then they're going to be challenged occasionally by the seller to show that they acted in a good faith manner in exercising that condition, that they took some reasonable steps to investigate or apply for or look into it, and they can prove that they did that, and that they made a reasonable decision to get out of the deal.
I did that on a deal of mine last year where as an offer done the first day that we hit MLS, I asked him if his clients were pre-qualified. He said yes. Then he came back after 3 days and said they couldn't get financing. I found it very suspicious due to the circumstances. So I demanded that if he wanted his deposit back, that he had to prove that they couldn't get the financing. I asked if it was bank or mortgage broker. He said mortgage broker. I said, then I want a letter from the mortgage broker stating so. Mortgage broker refused to put that in writing. So I said, call me. Mortgage broker called me and he said, there's no way that that guy could ever get financing. I said, does that mean the buyer's agent lied? He said, yes, he outright lied. So I phoned him back, gave him a good talking to about lying in the course of a deal. And I said, you're getting your deal back. And at least I had it sold the next day. But I have read cases where the buyer.
Yes.
I have read.
Oh, you're on the phone?
All right,
I'm
guys,
on
I need everyone on mute. It's here.
Vladimir, please
got it.
mute yourself.
I muted them.
Okay.
Okay, go on.
I did read one case where they only applied to one bank. They didn't apply to mortgage brokers who have greater abilities to finance deals. And the judge did allow the sellers to keep the deposit because of good faith. Do I have the name of that case in front of me? No.
I mean, that doesn't come up a lot in where that kind of situation doesn't come to me a lot, but I think it'll start coming more. And I agree. I think the courts are starting to take that more seriously. And I think litigation lawyers are starting to use it a lot more often. I'm using it a lot more often. The duty of good faith. It's now going into many lease lawsuits, and it's going to start coming up more and more.
Okay.
I actually refer to this as the Amazon effect. Buyers feel, because of the age group, they feel that they can just change their mind and they look to their lawyer and say, you know, what can I do to get out of it? Okay, well, we'll just say that we failed on financing or the inspection or whatever. And I think we're going to see a lot more of this in litigation.
Yeah, I think a lot of buyers think as long as they have some condition in there, it's just a get out of the deal free card, no problem. And I think the courts, because there's such abuse in the market, I think the courts are going to start moving toward holding people to account for their conduct. And you can't just take actions or waive conditions or exercise conditions without showing that you went through a proper, honest process, that it was that you made an honest attempt to fulfill it.
Agreed.
Tremendous. Alan, I'm going to read you something that Stephen asked. Stephen said, what if a buyer can get financing, but the property doesn't appraise for the price it was sold for and the buyer wants to back out? So I'm just going to qualify this question. I think what Stephen means, and Stephen, correct me if I'm wrong, but I think what Stephen means is in the event of a firm and binding offer, not a conditional one on financing. So in the event that we have a firm and binding offer and prior to closing, 3 days before, 2 days before, because that's usually when this happens, the property doesn't appraise for the price, can someone back out of the deal?
As far as I know, absolutely not. I mean, it's a firm and binding deal. If they chose to enter into a deal without conditions, then they're obligated to close the purchase. And they should have checked all that out before they bought it. And sometimes under pressure, I guess people make purchases and then find out they can't finance them, but that would be the fault of the buyer.
Terrific. And Stephen qualified this, and I'm going to take the lead here and just answer. Stephen asked, I guess for both conditional and firm, what happens in a condition? I would tell you, Stephen, I know we have Alan's expertise here, but I'm just going to step in and answer. If it's a conditional upon financing deal and it doesn't appraise for the amounts, that is a perfectly valid reason to get out of the deal. Having said that, there's no bank in this planet that will send an appraiser buy a property while it is a conditional deal. So you will never actually have that circumstance occur practically in law or in circumstance. So you have your answer both from Alan as to the firm deal, myself as to conditional. Hopefully that answered your question. Any other questions? Just bring them on, guys. We have time. We have a little bit of time left. Oh, Vladimir writes, can the financing clause specify that the buyer is not obligated to prove any steps? Essentially, can the parties contract out of good faith in common law? That's a very interesting question.
Yes, it is. Good faith, I mean, I think to some extent that you can try to. I think good faith is in the performance of the contract, and the contract is what's written. So, you know, if you specify
guys,
what actual
guys, can we all-
obligations are or are not, sorry.
There you go. I got rid of it. It's fine. Go ahead.
Okay. I think it's possible to specify what the scope of the contractual obligations are or are not. So if you specify that you don't have to apply for financing, for example, you don't, you know, or certain actions or obligations out of the contract.
Alan, I think we have a bad connection here. Is that Alan or me?
No, you're fine. It's Alan.
It's Alan that's cutting out. Oh, there we go. Sorry, Alan, you cut out there.
Oh, okay, sorry about that.
May I just add to that? Vladimir, may I suggest that you'd never, just as a matter of practical course, and I'm speaking as a conveyance lawyer, you never effectively want to contract out of good faith. What you would want to do if you are trying to engineer what it is you've asked about is simply put in a clause saying that the buyer in its sole and absolute discretion can leave this agreement in the next 3 days. A clause like that would have the same effect as what you're trying to engineer and would not contract out of good faith, which is really something you want both parties to abide by regardless. So that would probably just be a better professional tip going forward. Alan, with your permission, are you there? I think you're having some problems with your internet connection. Can you hear me? Alan, can you hear me or not? I think Alan disconnected. Okay. Oh, there we go. Alan, are you there?
Okay, sorry about that. Yes, my internet connection went down for a second. Sorry about that.
No
Yeah,
problem.
I agree with what you said.
All right, I
I
think,
think you cannot contract out of, can you hear me?
yes, we can. We can hear you now.
Can you hear me now?
Okay.
I
Alan, I apologize for this. We have a very bad connection.
wanted to add in, my view back. Thank you.
Alan, we can't hear you. It's not coming out clearly. So with your permission, while you readjust your internet, I'm going to sum up what I think you were saying, which is that I'm a genius and everyone should carry around a small picture of me in their wallet. Oh, maybe you're back. I'm not sure. Let's see. Nope, I don't think so. Okay. With respect,
Can you hear me now?
now I can hear you.
me
Yes.
now?
Yeah, now we can hear you. Are you there?
Okay. Is that okay?
Yeah, it is. I don't think we have video,
Yes.
but that's fine. We can hear you now. Let's try again. With your permission, Alan, I'm going to just read to you Hisaku's question, which is, can a buyer pay for a bank's appraisal during the conditional period? And I'm going to just answer that and say they can, but the banks just won't go for that. Hisaku is asking a question based on my answer over to Vladimir from before, where I said that with Stephen's question before, where I said practically it does not happen during the conditional period. Even if you offer to pay that for a bank, they're likely not to go ahead and do it. They will only do it on a firm deal, just plain and simple. Alan, I think you've been dropped, and which is too bad, because I was really enjoying our discussion, and I thought that what he was providing us with was a lot of very good information. My hope is that if we just hold tight, he'll come back in 2 minutes. And I will absolutely try to encourage him to do audio only so that we can continue. Though in fairness, we did get 45 minutes of Alan's time, which I'm very grateful for. I'm happy to answer any questions if you guys want to keep going until such time as he jumps back in. And fortunately, we have Ty here, who knows more than I do, who can also probably help me address some of these questions as well.
Oh, actually, I just unmuted myself. The question that I have is more for you. Do you find now that more and more what's happening is because of the cost of litigation, lawyers tend to simply bully in deals? You know, I had an experience a couple of weeks ago where I was buying a franchise restaurant, and the lawyer on the other side insisted that the HVAC unit on the roof of the single unit commercial property was not included as a chattel. Now, of course, you know, I told him to go jump in the lake. The contract very clearly stated that chattels were all included, not fixtures, but chattels. And, you know, the reality of it is I had to tell my client at the end of the day, the guy's just not going to budge. Like, if we go to court, you know, we're going to spend $50,000 on a $25,000 item. You know, let's just agree to pick up half the cost and move on. And I'm finding more and more that I'm getting these kinds of responses because everyone's aware of just how expensive litigation is.
You know what's interesting about that? There is a response to that. Dennis, give us a second. Let me just finish this, and then please feel free. There is something very interesting that I find, which is similar to a builder. People say, well, if this new build contract is completely in the builder's favor, what do I have to assure me that fundamentally they'll abide? And I say, well, really the only thing that you have in a new build contract is reputation, because people care about their reputation. And I find, Ty, that reputation matters also when there are two lawyers who are up against one another. I don't know about you, but I care about who it is I'm negotiating with. And if it is someone with whom I have ongoing relations and who I will deal with again, I treat them a bit differently than I treat lawyers who are fly by night. It is actually a very good reason to select lawyers who have a bit of experience under their belt, because their words have weight, and that weight for the other lawyer on the other side is the consequence that if they act like schmucks, excuse my Yiddish, you will have to deal with them again on future files. I find that that's really the only ability that you sometimes have to move the other side to reasonability when the court system proves too expensive for your issue. I hope that answers.
Let's be honest, we all have a shit list, and mine is becoming like the size of an encyclopedia.
Alan, welcome back. I'm sorry about before.
Thank you. Sorry about that.
No problem at all. Dennis, you had a situation and a question you wanted to bring up. Please feel free.
Yes, I did. I had a client in Toronto. They've built a custom house. They didn't like the look of their front porch with railings. So that was a requirement for the final inspection. They left the railings off until we sold the home. In the meantime, during between the selling of the home and the closing, they've popped the railings on, called the inspector back for a final inspection. What had happened was the inspector asked for the drawings immediately upon arrival. The front porch wasn't built to spec the way it looked in the architectural drawings. So now they're going through a process of a minor variance, and they got to appear in front of I don't know what to call it, in front of a group in the city to approve or not approve. And we may not be able to get this done by the time closing day comes around. I've had a brief conversation with the other realtor. They seemed really easygoing about it. The following day, I got an email saying that they've just switched their lawyer which kind of raised a red flag for me, made me feel a little bit uneasy about it all. I'm wondering, are my sellers safe as long as they address this, whether or not it happens before or after closing, given that we put a clause in the agreement to have this addressed before the closing date?
You put a clause in the agreement to have this addressed. Okay. Alan, are you okay if I take this one? Just because
Yeah,
this is really my bailiwick. It's
Go
conveying.
ahead, and I'll comment it once you're done if I have anything.
Okay, if you'd like to, you're more than welcome. You're our invited guest. People here are sick of my voice, so you're more than welcome if you want to take it.
Go ahead.
All right. So Dennis, very quickly,
And then I'll probably add something.
all right, Dennis, very quickly. So you're saying that the sellers bought this property with that defect? Is that my understanding?
No, they've built it, and the
They
front porch wasn't built to spec. I wouldn't say they built it. They did an addition, a cantilever addition in the rear, and a bunch of other things. But the front porch wasn't built to spec, and it's not a huge difference, but it's not according to the drawings. And apparently, the inspector's a little bit of a, you know what. So
I understand. Well, that being the case, I'm sorry, I thought it was that they had purchased the property that way. That being the case, Alan, I'm turning it over to you. I'm able to turn my brain off while you're here. So this is going to be yours to answer.
This is a Tarion insured home or new home, or it's just somebody privately built a home for themselves?
privately built. It's not a new build. It was originally a 1.5 story, and it was built with an addition to the 2nd story and a bunch of other changes. So it's not a newly built home.
And what does the clause say will occur prior to closing?
I'm not sure in so many words, but something to the effect of they will have the final inspection completed prior to closing date.
Well, you have to, I mean, in order, if it sounds like this porch and railing don't comply with municipal standards, so therefore they have to get minor variance approval from the Committee of Adjustment, which can take time, which is also, if you win at Committee of Adjustment, is subject to an appeal period and a potential hearing at, I guess, LPAT, formerly the Ontario Municipal Board. So it's kind of out of the control of the seller, you know, unless they can get through that process successfully before closing. It's kind of out of their control. So it depends a lot on how the clause is worded, but I would have thought, you know, I don't know. I mean, if they can't get it legalized, then they should be responsible, I suppose, for the cost of modifying it, tearing it down and replacing it, whatever it is, to put a porch in that does comply with all municipal standards.
Yeah, Alan, if I may ask a question, just and Dennis, I'll speak to you about this particular circumstance offline if you don't mind, but I want to just use Alan's expertise for what he knows and what we do not. Alan, if say this wasn't resolved by closing, if this matter just didn't have a resolution for the reasons you suggest of timing or anything else, would the buyer be entitled to walk away from this deal legally? Or would they only be allowed to preserve their rights to sue? That is to say, would something like railing and perhaps just a slab of concrete in front of a house, unaddressed, allow someone not to close a deal?
My opinion, no, it doesn't go to the root of title. It's not substantial enough. It's a relatively minor item, and abating the purchase price or paying a portion of the purchase price into escrow pending enough money to pay to fix it, maybe to hold it as security while somebody gets Committee of Adjustment approval and the appeal period expires, or until the work is carried out to complete it or replace it, whatever the maximum potential cost of that process is, that money can be set aside from closing and used to fulfill that covenant. In no way would I consider that substantial enough or sufficiently going to what's called the root of title. I mean, you could, to let somebody out of a deal completely, because the seller can convey almost all of what's required. The land, the house, everything is fine except for this porch and railing, and it can be fixed one way or another.
So to answer your question then, Dennis, you're getting your commission, but let's talk offline about that particular issue. You know, Ty, myself, anyone, we can discuss the furtherance of how you deal with that procedurally afterwards. But that's very interesting. Maybe you could take the last 2 minutes that we have here, Alan, and just talk about what root of title means, because I use that term a lot on this forum, but I'm not certain that people are really very clear of what the ramifications are of a root of title defect versus an ancillary defect, such as the one we've just been discussing with Dennis. Seems like a good place to end off.
Good question. I mean, I only see the ones that come my way. So, I mean, most of the time it's real estate transactional lawyers making those assessments. But I think if it's clear, let's say that somebody purchased a property to redevelop it, and that was clear from the agreement of purchase and sale, and there's restrictions on it that prevent building on it that weren't disclosed, major, you know, easements or sewer mains, or I don't know, something, you know, a property that can't be developed for the purpose intended, and the purpose was clear in the purchase, and those restrictions were not apparent when the deal was made, and then they come out when the lawyers start searching around before closing. Those kinds of things can get you out. Serious defects in the amount of land or in the restrictions on the land, or registrations on title that severely affect the property that weren't disclosed and can't be taken away.
What about if there's a parking spot that's missing from a condo? That's the one I always wrestle with, because a parking spot has an accredited value of $30,000. You can often buy another one, but at the same time, it is fundamental. That is the actual property that is being promised to be conveyed pursuant to the agreement.
So you're saying that it's specified in the agreement that there's a parking space and there isn't?
Correct. Or alternatively, that there's exclusive use, and instead you find out that there's just 1/100th ownership of a garage, which means that, you know, they can go ahead and rent it to the general public if you like. You have no right to the parking spot. There's a whole bunch of these types of things you find out in older condos where parking becomes a fundamental problem to the condo itself. And then the question is that a root of title issue, given that it's an actual pinned property mentioned in the agreement and you're not able to convey, but it has a very minor cost relative to the actual condo itself?
I've never come across that. It sounds like it comes up a lot. How do you feel about them? Or I'm throwing it back to you.
I tend to think that because it is an actual described parcel in the agreement of purchase and sale, that it goes to root of title. That parking is different than another ancillary damage, and is a critical component of a condo lifestyle. And what's more, because it's mentioned specifically and is usually an allocated PIN, it does go to root of title. Ty, what's your opinion on this one?
I agree with what you just said. If you're buying, really, when you buy the condo, a few parcels, I guess you're buying a unit, a parking spot, a storage locker, etc., but they're specified in the agreement. And if you can't convey one of those parcels at all, doesn't exist, or you don't hold title to it, then I think that could go to the root of title. I agree.
That's been my opinion as well, but I haven't found it tested in the courts yet.
I haven't either, but I agree, especially with parking. When you're talking downtown units, they're usually, it isn't a simple choice of just picking one up for 50 or 100,000, which is, by the way, how much they cost. But they're not available because of the parking allocations. Usually there's one parking per unit. And if you don't get in early, you can't buy the second unit, and they're all sold out. So people with cars that intended to have a parking spot, I think it's a fundamental issue to the ownership.
Okay, well, it looks like all three of us agree on that point. So that gives me some confidence in what I've been telling clients for years. Alan, I can't thank you enough. We've had 35 guests during the course of this session, which means that we'll have over about 150 people view this over the next 24 hours. Your knowledge will, of course, be sprinkled amongst our group, and that makes us better agents. It makes us better lawyers. Having people with your experience is a vital component and one that is missing from the average real estate and real estate conveyance lawyer's experience. I can't thank you enough for the generosity of your time and for your willingness to come on the forum. We have an open invitation to you to come back anytime you like. And what I would say to people is that similar to so much that takes place on this forum, this forum is really about paying forward. These services, these talks are free, but all the professionals here who give up their valuable time are obviously doing so at the expense of their files. And so the best way to pay back is to consider people like Alan when you actually have a litigation issue. As you can see, he knows his stuff. I will vouch for his firm and his colleagues, certainly, and other people much more knowledgeable than myself vouch for him directly. As a result, I would strongly encourage you to pay back in kind. Alan's been very generous today. And Alan, I just want to say a sincere thank you from all of us who have attended. It was a good attendance today, and I was thrilled to have you as part of our forum. Thank you.
Thanks for having me. I really enjoyed it. It was a pleasure. I also learned a lot. Thanks very much.
Wonderful. Everyone, thank you very much. This will be posted within 2 hours.
Thank you so much.
Take care.